Hello everyone, my name is Al-Hussaini. I'll give Rosa legal advice. Rosa, your situation falls under the tort of negligence. Negligence, as briefly defined by Winfield, is a breach of a legal duty to take care by an act or omission that injures another. There are five elements of negligence: actionable damage, duty of care, breach of duty, causation, which is divided into two parts: factual causation and legal causation. Factual causation means that in fact the defendant caused the harm to the claimant. Legal causation means that should the defendant be legally responsible for the action. And the last element of negligence is defense. In your scenario, you can bring a claim against the Dr. Khan, and you can bring a claim against the gallery and the church together because they have a joint issue. We will start with your claim against the gallery and the church. In terms of actionable damage, you fell under personal injury. In regards to duty of care, they owe you a duty of care. In the case of Wilson and English in 1938, the House of Lords decided that an employer had a duty of care to ensure a safe system of work to his employee. So both gallery and the church failed to do so by using a chemical solvent material in their work environment. And the Health and Safety at Work Act 1974, Section 2, Subsection 1 states that it shall be the duty of every employer to ensure, so far as reasonable, practicable, the health, safety, and welfare of all his employees. And again, the gallery and the church failed to do so under this act. After we have established the duty of care, now we will discuss the breach of duty. The breach of duty means that the defendant's conduct must meet a certain standard. The standard of a reasonable care is outlined in Hazel and British Transport Commission 1958 case. This means that negligence liability is both premised and dependent upon fault. The use of chemical materials in the gallery and the church was a fault and was an action without considering a reasonable care. Moving to the fourth element of negligence, which is causation. In terms of factual causation, you need to show that the gallery wrong in fact caused your harm. One important element of factual causation is the but-for test. The test states as follows: but for the defendant's negligence, would the claimant have suffered harm that she did? The test is not applicable here because your situation is based on a multiple potential causes of the harm that are operating cumulatively, and the situation is considered on the exceptions where the but-for test is not applicable. In the case of Bonington Casting Ltd. and World Law in 1956, an employer suffered from a disease because of the inhalation of dust at work. The employee sued his employer. The but-for test also failed in this case. However, the House of Lords adopted a new test, which is the material contribution test. The test is that if the defendant's breach could be proved to have materially contributed to the claimant defendant the disease, to the claimant developing the disease, then the defendant will be liable for all of the loss. By that and other factors, the court held the employer liable for the injuries. And also in the case of McGee and National Coal Board in 1973, the House of Lords decision wasn't distinguished from Bonington. They all have mentioned that they materially increased the likelihood of the claimant developing the disease. By these two cases decisions, the gallery and the church could be held liable for your personal injury. The second part of causation is the legal causation. After we have established the factual link between breaching the duty of care and your damage, it is important now to see in law whether the defendants may be held liable. There are two tests in legal causation. The first one is asking whether the harm was too remote consequence of the defendant's negligence, and the second test is whether any event could be said to have broken the chain of causation. In terms of remoteness, the test asks whether the negligence action was being unforeseeable by the defendant at the time of the action happening, and if the action was not foreseeable, then the cause is not established and the claimant cannot proceed. In the case of Huggs and Lord Advocates in 1963, the House of Lords found that the defendant liable, holding that it was reasonably foreseeable that the kind of damage would burn. Therefore, the exact means by which the burns occurred did not matter. In your situation, it's clearly foreseeable that the use of chemical materials would result in the injury. The second test is the break of chain of causation. The court stated that there are three elements that break the chain of causation. First one is the act of the God, second, act of third parties, and third, act of victims themselves. In your situation, you have used this material by yourself in your house. So you broke the chain of causation. In the case of McCoo and Holland and others in 1969, the House of Lords held in favor of the defendant. The court stated that the claimant action was a new intervening act that broke the chain of causation, and the defendant was not liable for the claimant's broken ankle. Also, in your scenario, might find like you broke the chain of causation and you have volunteered in the church, which the court might find a reason for not holding them liable. The second claim you can bring against is the Dr. Khan claim. Again, in this case, we'll go step by step through the elements of negligence. In terms of actual damage, it's also a personal injury. In regards to duty of care, Dr. Khan owes you a duty of care. In the case of Pippin and Shepard, the court stated that doctors owe duty of care to patients. In terms of breach of duty of care, in the case of Willem and Firm Hospital Management Committee in 1957, the court set a test called Willem test to determine whether the doctor and other professionals breached their duty of care or not. The test is that the claimant must establish that the defendant failed to act as a reasonable person would in their position. This standard is higher in the case of professionals. They must act as a reasonable professional would. Dr. Khan failed to act as a reasonable person, especially as noted by the medical community that the exposure to yttrium increases the chances of developing this particular cancer. According to this test, Dr. Khan breached his duty of care to you. Moving to causation, in terms of factual causation, in regards to the but-for test, which is the answer clearly here is that the doctor negligently diagnosed you, and now you are suffering the harm because of his wrong diagnosis. The second test of factual causation is the balance of probability standard. To succeed, a claimant needs only to show that there was more than 50% chances that the defendant's breach caused their harm. In the Greek and Scott in 2005, the claimant had only 42% chances of survival. Thus, the court required the claimant to show the doctor's negligence made it more than 50%. In your situation, we know that you had a chances between 45% to 55% if Dr. Khan diagnosed you well. So you have the required percentage of the balance of probability and what the court need to hold Dr. Khan liable. In terms of legal causation, again, we need to examine whether the test of legal causation are applicable here. The first test of remoteness is, again, whether the consequence of negligence action were so far as removed from it as to have been unforeseeable by the defendant at the time the action occurred. It was expected, according to the medical community, that this material would develop cancer, but the doctor failed to foresee that. Indeed, in the case of Page and Smith, 1996, Lord Lloyd adopted the foreseeability test, which is whether the defendant can reasonably foresee that his action will expose the plaintiff to the risk of the injury. And in your case, the doctor did not foresee it and caused you the injury. The second test of legal causation is the intervening act. You didn't break the chain of causation, and the test has nothing to do with your situation in regards to Dr. Khan's negligence. In terms of the final element, which is defenses, Dr. Khan has no defenses to bring against you. There is no contributory negligence. There is no non-fit injuria, and there is no illegality can bring against you. To conclude, as discussed before, the only claim might success with you is your claim against Dr. Khan. The other two claims have more strong defenses than what you are claiming. Thank you very much.